a young person committed serious offences and that he even intended to stab and probably kill the deceased had he not been stopped. He has already been using alcohol and drugs since 2002, in other words, since he was 14 years old. Although he was still supposed to be staying with his parents, he had to sleep over in a hostel due to lack of space at home. We all know that hostels are generally bad places and that it is certainly not a place for a young child. It is therefore hardly surprising that he turned out the way he did. His school principal reports negative behavior at school. He hasn't even been allowed back at school since he has been released from custody. However, since his arrest, he has been detained at the Walter Sisulu Juvenile Detention Center until I released him on warning late last year. The report from the detention center, which was handed in as Exhibit H, reads quite differently from Exhibit G. It is as if we are dealing with a different individual. According to this last report, he seems to have quite a positive prognosis. The reason I suspect is that he has been submitted to a structured environment, which was all that he needed to become the person which he was supposed to be. What accused number 3 needed, and what he still needs, is strict supervision and discipline. I'll then turn to accused number 4. He's also still relatively young. He is single, he has no dependents, and he's unemployed. He is also a first offender. He has asked his mother, who testified, to apologize on his behalf to the deceased family. His mother told the court that he is generally not an aggressive person. That probably explains why he did not actually hit the deceased with a monkey wrench when he had the time to do so. Although he kicked the deceased once, he basically only threatened him with the monkey wrench after that. Unlike accused number 1, accused number 4's actions did not actually kill the deceased. He only formed a common purpose with accused number 1 at a very late stage. Clearly, he should be treated more leniently than accused number 1.
Well, live scenes there from the Johannesburg High Court, the magistrate going through the causes and the reasoning for delivering his verdict, which we have yet to hear, going through the first offender and the third offender, saying that the first offender could face a sentence of possibly 20 years, going through the reasons for this judgment. So the proceedings there just getting underway. We will have more for you coming up in our later bulletins. We have our reporter Manqoba Mqunu there, who will give us updates on what exactly comes out of those proceedings. Well, we're looking now onto your business news. The domestic manufacturing sector remains under pressure. Barclays Purchasing Managers Index dropped to 43.5 points in January. The PMI is used as a gauge of the manufacturing sector's health. That's 2 index points lower than that registered for December, and 5 index points are lower than 2015's average number. The Business Activity Index, which indicates actual manufacturing output, fell 4.9 points to 37.5 points. That's the lowest registered level since 2009. The one index that ticked was that of price. Manufacturing costs are on the rise on the back of a weaker rand and higher imported inflation. China's official factory activity slowed to a 3-year low in January. This is according to the Purchasing Managers Index. It adds further gloom about the state of the world's second largest economy. This gauges the health sector of.
However, the court is not of the view that these are substantial and compelling circumstances. We quite often find that people who commit this type of crime are provoked or under the influence of liquor. For example, in the matter of State versus Mkwati, 1985, 4 SA 22T, the accused was also subject to provocation. In his case, he actually was a bit older. He had a family. He was under the influence of liquor. The court, however, warned that when a person loses his life, the court should, through its sentence, clearly show that life is not cheap in the eyes of the law. People who resort to the use of a knife to solve the slightest grievance should also be taught that this will not be tolerated by our courts. In such cases, long-term imprisonment would be the only appropriate sentence. The deceased was unarmed. He was already clearly injured by the time accused number 1 decided to stab him. He wasn't satisfied after stabbing him once. He stabbed him a second time. We do not know what would have happened if other people did not start to intervene. It is not acceptable that a person should be killed in this manner. And he is completely harmless and helpless. In the case of accused number 1, I find that there are not compelling and substantial circumstances which would entitle me to deviate from the minimum sentence. In fact, I believe that the minimum sentence on its own would not suffice to appropriately punish accused number 1 for what he had done wrong. A person such as accused number 1, who already has a previous conviction for a crime of violence, is a danger to society and should be removed from society for a very long time. In the case of accused number 4, I believe that I do have sufficient reason to deviate from the minimum sentence due to the fact that he didn't really injure the deceased other than kicking him once, and he didn't actually cause his death. In the case of accused number 3, the recommendation was that he should not be imprisoned, but that the passing of sentence should be postponed. Mr. Tlo Butler, the prosecutor, supports this, and I have no reason not to impose that. Accused number 3 was convicted of 2 counts. On each of the 2 counts, the court, acting in terms of section 2971A Roman 1 of the Criminal Procedure Act number 51 of 1977, as read with section 78 of the Child Justice Act number 75 of 2008, postpones the passing of sentence for a period of 5 years. Accused number 3 is released on condition that he submits himself to the supervision and monitoring of the probation officer, and that he complies with all programs he is ordered to undergo. He must report to the social worker, Ms. Moyo, at office number F20, Alexandra Magistrates Court, on the 4th of February 2016, before 4 o'clock in the afternoon. Accused number 3 is further ordered to appear before this court on the first court day of February 2021, which I think will be the 2nd of February, at 8:30 in the morning. He must make a note of this date so that he should not be in default. Otherwise, a warrant will be issued for his arrest. 2021, yes. If accused number 3 complies with all of the conditions, he will then not be sentenced as such, but if he does not, he will be brought back before me, and I may then impose an appropriate sentence. In terms of Section 78, subsection 3 of the Child Justice Act, the probation officer is ordered to provide this court with progress reports on a regular basis. If accused number 3 should not comply with these conditions, or if he continues abusing alcohol or drugs, he will then be asked to appear before this court prior to that date mentioned, in which case the court will then have the right to impose a sentence, which may include imprisonment. Does accused number 3 understand this? In the case of accused number 4, the court has decided not to impose the minimum sentence, and he is sentenced to 10 years imprisonment. In the case of accused number 1, he is sentenced to 17 years imprisonment. The court orders that all of the accused will be unfit to possess firearms in future. The relatives of the deceased will have the right to appear at the hearing of the parole board at any stage when the prison should consider parole in the case of accused number 1 or 3. And they may then give their opinion as to whether either should be paroled or not. Thank you. The accused may then stand down. I just want to make the entry in the court book. Which was the murder case, count 1 or count 2? Count 1. I'm going to adjourn for a few minutes so that the recording equipment can be removed. We'll adjourn for 5 minutes. Call me when you're ready.